right, so hello again. This is Ben Hitchcock Cross talking to you today. I did want to take a second out here without any music to dedicate at least this episode, if not almost the whole channel here, to Carl Krieger. That is the father of Debbie Krieger, aka Debbie Keither, aka Dr. Keither to you. Um, and let's say that he had his funeral about a week ago, and it was extremely moving. And by no means am I from that let's say faith body. That culture is their culture is not my culture, but it was very clear to me, and it has been for a long time that the presence of Carl Krieger is much greater than even his existence on Earth, and that is kind of hard. He was suffering for quite some time, and I hope I'm not being too personal by mentioning that. Let's say he was not fully with us all the time, especially at the end. But in the same way that, let's say, Debbie Keither got behind me and certainly this channel and certainly so many other people and pushed. It didn't take, um, I don't want to grow today for an answer. And I think that that's, if nothing else, the legacy of Carl Krieger that's touched me here today. So um, that's what I wanted to mention before we go on to doing what we do here. Okay, so as I've sort of been hinting and foretelling here, the government of the state of Wisconsin has been coming after this channel from all sorts of directions here. Um, for sure, the Department of Workforce Development, but we could also add to that the Department of Corrections. Let's say that many people at the Department of Corrections did not take kindly to having the Novak hearing appear on the air. For some reason, and this is something I think is the fundamental issue for me anyway, I cannot understand, I cannot fathom to me how employees who take public dollars to do their public jobs in public can get mad when somebody shows the public them doing their job. I don't understand it. Not even for a second. So that I think more than anything else, if you want to understand what I think is the problem here, is that Secretary Carr, Mac DeFessahaya, and many others feel that they should be able to perform their government work behind closed doors, and that anybody criticizing them is outrageous um, and unethical. I think we can be very clear that that's how they feel. Now let's talk about the Department of Corrections here. We the two attorneys that we've seen before are Eric, I believe, and Michelle Zacard. And we have a new one to the list who I've had many people complain about to me as Ben Hitchcock Cross of Cross Law Firm, but I had not had a chance to um, engage with her to work with her before this. But this was a revelation to me. It certainly confirmed, I think, what I had heard about, let's say, the intensity of the work when dealing with Andrea Olmandson. And so I will, of course, let the documents speak for themselves here. But I want you to understand right away when we're doing our analyses here, just on First Amendment retaliation or violation of free speech rights, we just want to keep in mind that Tony Evers' name is right on there. So, and it's addressed to yours truly in care of my client here. So, and let's be clear, well, there's a lot of dirty laundry that's going to come out here, but you tell me basically if the point of this document is to chill free speech or something else. Because, by all means, anybody can be wrong. Dear Attorney Cross, we really need to discuss discovery, and I'm sorry, I will lay out the sort of the background here, and it is this. We are in a middle of a discovery before the hearing. Each side gets to ask the other side questions, demand documents, things like that. We have asked them questions and asked for documents, some of which they have refused to give to us until we sign this document here that says stipulates an order that the parties will not use records produced in response to these requests identified below for any purpose other than the litigation of this action that exists between them at the time of the stipulated protective order. So, for example, and this is, I think, very important here, which goes to the issue here. And we're asking for, just for example, all of the Department of Correction, like sexual harassment complaints from one officer to another officer, and they're refusing to give them to us because they're alleging that we're going to put them all up on YouTube, which may or may not be the case, but it certainly is not a reason to refuse to give them, and certainly, yeah, so let's just see what they state the reason. DCI, which I assume means Department of Corrections employees who may have been falsely accused possess a significant reputational interest and they're preventing the dissemination of false accusations. Okay, interesting. Where any witness who may have given statements and undeserving of being doxxed or otherwise harassed. Okay, I again, I sort of dispute the question of whether a public employee can be doxxed. Certainly by a witness in a, I think what they're worried about there is people understanding who's been saying what and what they've been saying, and that coming out. The purpose of this litigation is to obtain redress for and defend against alleged grievances. Therefore, it is hereby stipulated and agreed by the parties hereto that their undersigned counsel, subject to approval of assigned administrative law judge, as follows. The parties will not use records produced in response to these requests identified above for any purpose other than litigating the action that exists between them at the stipulated protective order is signed. Okay. So, needless to say that we were not going to sign, or at least my client there was not going to sign an order that would limit her ability to expose, for example, other people being sexually assaulted, for example. She wasn't going to do that or even consider that, or even understand why she would do that for just agree to it. Or, and let's be clear on this situation here, they were refusing to produce the discovery unless we agreed to this condition, which we were not willing to agree to. So they hadn't filed a protective order or anything. They just said, hey, we're the state of Wisconsin, we can do whatever we want. And then they did whatever they wanted, which was not produce that. But we, in their opinion, did not produce discovery to their liking. And we've discussed this on other issues where they have, I think it's clear to say, and this is particularly with the Department of Corrections and this legal team here, they will have a theory of the facts. And if you even put any evidence that disagrees with their theory of the facts, then they will have a big problem with that. And we've definitely seen that in Novak. We've seen that with Mr. Mullebach as well. If you say anything, again, that opposes whatever they think, then it's outrageous and we need to, everything needs to stop. Alice DeLau put some end to that, but not as much as I think we would all hope. But, so that's the situation. So they haven't produced things because they say, hey, you're asking for things that might embarrass people, and they have said that your person, you've denied with it, and we'll get into this. I'm sure they'll speak for themselves. To begin with, your objections and responses to the request to admit were untimely. Okay? Please admit and acknowledge that they were untimely, and these requests are deemed admitted. We'll move on. I'm not going to make significant arguments on all these things because I've made significant arguments to this. We're going to focus on, do you think this is designed to chill free speech rights or not? Okay? Here we go. On March 19th of this year, I sent you a very lengthy letter concerning, among other things, the multitude of misrepresentations and falsities set forth in the written discovery responses submitted by your office on behalf of your client. False statements in the ERD complaint itself, and patent falsities in some of the denials of the request for admissions. These are all quotes by her. This is what she said to us, that we were being false, okay? It appears that the lack of candor that permeated Miss Stoller's discovery responses, and this much I will be clear, lack of candor came up in the previous round of this because they alleged that we walked out of a deposition that we didn't walk out of. And the judge alleged that we walked out of a deposition that we didn't walk out of. And we explained to the Michelle Zacard that it was a lack of candor to not join me in explaining to the judge that we did not walk out of a deposition. And for him to find, on the basis that we did walk out of a deposition, was basing a decision on something that she knew to be untrue. So she had both the judge and her had a duty of candor. This is also, I think, the situation there where the judge tried to ding us, that is to say, make us pay costs and fees here, but didn't really read the whole statute and just left out the middle part of the statute there. We raised an issue of candor at that point. And candor is an interesting concept. It means not simply telling the whole truth. It means sometimes you have to, if you see something as here, a false statement being perpetrated, you have to, even if it goes against you, you have to correct that statement. That's a duty of candor, okay? It appears that, if you will not concede that all the respondents were, the DOC does not prevail, okay, you will need to correct the lack of candor. Perfect. Look, let's say I'm the worst discovery person to answer, then maybe these responses are perfectly legitimate. Okay? And then here we go. And I'm going to skip over some of that to be fair. Normally put the whole Joker up, but I just have a paper here. I have observed that despite your failure to find time to respond to this discovery, you have found time to create and upload YouTube content pertaining to this case, including content that defames Lieutenant Miller. And if you don't recall that thing, because not many saw it apparently except for people at the Department of Corrections, this mentioned the allegations in the complaint that mentioned Lieutenant Miller. She's alleging that we're defaming a public employee by reading aloud a public complaint, having allegations against a public employee. That's wrong on many levels here. Your treatment of Miss Miller is regrettable. Miss Miller is a hardworking, innocent public servant. I see that attorney William F. Sutton, she says Sutton, but I think she means Sultan, is representing you in the defamation action brought against you by Mr. Furman. And when she says Mr. Furman, of course, she's going to be meaning the administrative law judge and colleague of the administrative law judge on this case is suing us for defamation. That's what she's talking about. That stems from other YouTube content. It's absolutely true that Calvin Furman is suing us for content that we had on YouTube about him. That's absolutely true. Thank you for mentioning that. That you have created and uploaded. Perhaps you might seek Attorney Sutton's counsel regarding your statements that malign Miss Miller. And it's Attorney William Sultan. He's fantastic. Anybody... especially I would say in the area of more, I was going to say civil rights, but he really does everything. But I'm talking about, he's in some very high profile, again, what I would call civil rights as opposed to the sort of constitutional civic rights thing that I do. That's a really niching things a lot, way too much. But because this is definitely constant. He's a fantastic lawyer for a lot of different things. But again, particularly for public, I mean, he's just good. So it's true. Perhaps you might seek his counsel regarding the statements that malign Miss. Well, there's a footnote. Let's just see. For that matter, YouTube content also maligns other current and former public servants. Current, right there, she's talking about Kevin Carr. She's talking about who may still have been there at that time. She's talking about Carrie Byers. She's talking about Chrissy Preston. Again, that's them showing them doing their job and me commenting on them doing their public job in public. And she's talking about Mac DeFessahaya. That's absolutely she was talking about. Who's definitely um, raised issues with her being on YouTube, as we know the letter and so forth. Um, yeah. Okay. And let's just sort of imagine a world in which you can malign the Secretary of the Department of Corrections by showing his hearing on there, or indeed even commenting on them, or indeed even saying something negative about him, or indeed even, saying you don't think he's fit to be doing his job, or remarking about the deaths in his care, or the fact that he was suddenly removed without explanation. You know, those things. Let's just imagine a world, at least in the United States, in which those things were against the law. This government employee who writes letters with Tony on behalf of Tony Evers sure can. In any event, we really need to discuss the outstanding discovery that you owe. Oh, as I have previously communicated to you, I really don't want to see another attorney dig themselves any deeper than they already are, and I would think that Attorney Selton could probably provide you with accurate and dispassionate advice. All right. In any event, let's just wonder, maybe that was it and she's over YouTube. Let's see. In any event, we really need to discuss the outstanding discovery that you owe the Department of Corrections. Whether or not you will concede that all of your requests to admit are deemed admitted due to your failure to timely respond. And if not, your responses to requests to admit that I believe you need to correct. I just want to be clear, so very clear, why that's extremely disingenuous. Because this person, even at this time, knows that there's extensions to all of discovery that they themselves had authorized at this point. And that there will have been a further extension that they will have authorized after this point. Unbelievable. But hey. Moreover, we need to discuss a protective order that will allow you to obtain discovery that you seek, but limit its use to this case. If you seek these records for use in your YouTube content, the way to go about requesting and obtaining them is by making a public records request, not by discovery request. And I think that sentence right there in its entirety explains what exactly the problem is. They assume that we want discovery for the purpose of a YouTube channel because they imagine, again, that any reporting of what they've done, even the allegations against them, is necessarily, even the factual allegations that were proved correct, because that's what that agreement demands. Even I kind of wonder if there's some complaints about some high-level people that they don't want us to know about, because we still don't have them. And as we all know, they'll filter things through public records that they won't filter through discovery. So, they get to assume that what we want is for YouTube and then not give it to us. And then we have to spend time, energy, and effort at our own expense to fight it and get it out of them. Because the state of Wisconsin has not made a rule, that's what the court decided, that the state of Wisconsin can be penalized for screwing around with discovery. So that's what you might think. They just might well be incentivized to play unfair since everybody else has that rule. Okay. We all need to discuss it. Any plan that you may have to subpoena former DOC Secretary Kevin Carr. Okay, I guess he's former at this point. Or for that matter, Keith Curtin DWD Secretary Amy Petchak, neither of which she represents to any capacity whatsoever, to a depositions. For reasons that have been previously explained to them, they have no information to provide. And so that's what their tactic had been there, was to simply sign an affidavit, both Kevin Carr and Amy Petchak, saying that we have no information about this case whatsoever. And then there's because they were acting secretaries, there is a case that says that all they have to do is sign an affidavit that says they have no information, unless you can prove that they're lying, then they can just go about their merry way. Well, Kevin Carr is no longer a secretary anymore, so that doesn't apply to him by any stretch of the imagination. But guess what? We subpoenaed him, and guess what? He didn't sit. Oh, but the Department of Workforce Development jumped up and immediately granted a stay for him. The things that we're going to get into here are, at least in my mind, are just shocking, and there's a lot more. But hey, that's what we do. Name the names. As an alternative to moving forward the discovery process, a perfectly reasonable step forward is to simply dismiss the case. The ALJ's order dismissing the probable cause appeal is a significantly communicative. Shut up. Stop putting people on YouTube. Don't criticize your betters. I believe that something along those lines is going to be the net result of the merits hearing as well. Shut up. Stop criticizing your betters. Go away. Don't put things on YouTube. In addition to having the probable cause portion of Miss Stoller's case dismissed, oh, here we're going to go. We're going to get through the worst things that Ben Hitchcock, the personal failures of Ben Hitchcock Cross. Are you ready? Let's do it. Let's do it. I have observed on your deliberate indifference channel that you were unsuccessful in Novak, Garcia, and Tate. I have also observed in Westlaw that the magistrate judge Joseph granted summary judgment to the defendants in your Pease case. I have always found it helpful to staff my cases with colleagues. If you find that you aren't able to fully staff your case in a small office, then there is the Wisconsin Bar's Lawyer to Lawyer directory, which I found to be an invaluable research which I was starting out 26 years ago. These days it's online and can be accessed at this link below. There are multiple seasoned attorneys willing to share their expertise, including giving reliable opinions as to the merits of a case. Drop your case and shut up! Thank you for your consideration. Best regards, Andrea Olmandson, Assistant Legal Counsel, Attorney for Respondent, Office of Legal Counsel, Wisconsin Department of Corrections. In other words, an attorney working for Tony Evers. Says it right there on the letterhead. So, we got 4 more of these that were sent on May 21st, May 23rd, and June 3rd. By the way, during all this time, I'm on vacation. And all this time, this person is getting every email that she sends, she's getting a bounce back notice that tells her that I'm on vacation. She hasn't yet accused me of being on drugs, but I'm sure that might follow. All right, so there we have it. I guess part 1 here of the Olmandson saga. We'll go, I think, through the analysis of First Amendment violations of free speech here. A little redundant, but hey. So we'll do that. But I think that this letter in it should speak for itself, and then we'll go from there. So, as always, I appreciate you sticking with us. I hope you can understand. And this is just the beginning, their first salvo it's going to get much worse. Why it took us a little bit of time to put that out there. But hey, um, this is what I look like. That's what my mother always used to say because her mother used to say that when we would complain about how ugly our pictures were. Take care.